Hello and welcome everyone. You're joining us for our webinar today on Guardianship for Adults, the Basics. My name is Jan Combs. I'm an Autism Resource Specialist with the Autism Society of North Carolina. I'm also the mother of 4 children. My youngest son, Daniel, was diagnosed when he was 3.5 some years ago with autism spectrum disorder, and I actually have gone and gotten guardianship for him, and this is the result. This webinar is a result of a lot of the research and information that came from that initial journey into the world of guardianship. So I want to make a disclaimer right away. The Autism Resource Specialists are not attorneys. This presentation is intended for sharing information, not to be construed as legal advice. If you have more in-depth questions, we encourage you to seek the advice of an attorney or a trusted advisor for your particular family situation. So looking at, is guardianship the right option? Why plan? We want our loved ones to enjoy the best quality of life possible. We also want relief from some of that overwhelming stress and worry that we as parents carry on our shoulders when we have a child with special needs. We don't know what the future will hold, where our adult individual will be as far as functional abilities, independent skill levels, what may be unique situations and need support there will be. But planning for the future of your adult child is a most difficult and emotional topic. It's difficult, but it's very vital. It's a discussion you need to have with your spouse, family members, or trusted others. So let me suggest you begin the proper framework in order to provide the best care possible. The fact that you're joining us and listening to this webinar, you're starting in the right direction. So let me encourage you to continue your research, educate yourself, and understand those significant and serious issues. Learn about possible options and alternatives. And if guardianship is the best option, then understand the procedures and the process for seeking guardianship, your legal responsibilities and obligations, and also just keep in mind to be open to the options that continue to belong to an individual who has a guardian. So remember that there is no perfect plan, there's no perfect answers, but don't let this stop you from moving forward and making those important and necessary decisions. So we're going to look at some considerations. Oh, excuse me. Sorry. So we're going to look today in the next hour. The overview for today's webinar is we're going to consider the legal considerations. We're going to define the terms for both guardian and guardianship. We're going to consider the main types of guardianship for adult guardianship. We want to explore the guardianship process and how to go about obtaining guardianship. Although guardianship should never be an automatic choice, you'll definitely want to first consider some less restrictive alternatives before considering guardianship. So we're going to take a look at a few of those alternatives. And then we're going to wrap up with a quick summary and review, and we have a slide with some additional online resources for you. So some considerations to think about in North Carolina. Usually parents start thinking about guardianship when their child with special needs is about to turn 18. When a child turns 18, that's considered the age of majority. So no matter what their developmental or functional level, they're considered an adult and assumed competent. The law assumes them capable of exercising their rights, making decisions that affect their personal health and welfare and safety, and accepting adult responsibility and consequences in full. So families need to discuss what supports are needed now and in the future. Parents are no longer recognized by the law as the legal decision maker when it comes to their child's education, their health care, or financial affairs after the age of 18. So many families don't always realize that they have to go to court to change this. So if you are a parent and you want to continue making those legally binding decisions for your child after the age of 18, you must take those necessary steps of going to court and establishing guardianship through the court system. The adults who cannot take care of themselves, adults who cannot take care of themselves, they can't make or communicate decisions in their best interest. And that part of the last bullet point that you see on your screen, that make or communicate decisions, that's very important to note, or handle their assets, may need some kind of protection. So if the individual is incapable of making those independent and informed decisions, then this process should be pursued only as a last resort and after careful consideration of other alternatives and options. So what is guardianship? It's a court process. It's a formal legal proceeding. It's a civil procedure. Each state has different laws and statutes that govern the process and the guardian's activities. So the states also separate out guardianship for minors and adults. Guardianship might also be necessary in cases of chronic health or mental health issues. Dementia, you may see an individual with loss of skills and ability due to advanced aging, and also consideration for those adults with disabilities. And that's where my focus is today, for those adults with disabilities. So guardianship is a valuable tool which can be used to protect an individual who's not capable of making appropriate personal or financial decisions for themselves. And this significant legal process provides a standard of decision making. The guardian's authority is defined and limited by a judge's order in state law, and we're going to talk about that later in the presentation. But guardianship is designed to protect those individuals at risk of abuse, neglect, or exploitation, and offer safeguards. Guardianship does provide a clarity as to who can make decisions and who has the authority to act in times of emergency. You can start this process, but no sooner than when your individual is 17 and a half years old. Guardianship is very restrictive. It does remove the rights and privileges from the individual. So you want to make this as your last choice and check all the other alternatives out completely. But once appointed by the court, the guardian is given the authority and legal right to make necessary decisions for and act on behalf of the ward. And there is a legal obligation for the guardian to make those decisions based on what's in the best interest of the ward, and they should preserve as much as possible the ward's decision-making process. So if appropriate, you want to discuss with your young adult the need for decision-making support, and you want to start this series of discussions long before their 18th birthday, if at all possible. You want to focus on assessing the individual's decision-making process, not just on the quality of the decisions made. It's important to review the level of support needed periodically. You know, it can be a very emotional time in your life to realize that your child of 18 still needs protections. I know it did for me. For my son, I worked with him for many years, even with his education. I knew his strengths. I knew what the limitations were, but it was still a very emotional time to see it in writing, how much help and need and support he needs. But don't feel like you have failed getting your child to a place you wanted them to be at this time. So guardianship is designed to authorize the guardian to help the ward when the ward cannot make those safe or appropriate choices. You don't want to have to jump into the option of guardianship in reaction to a crisis. Otherwise, you may choose or react with a more restrictive avenue than is necessary. So considering, does your individual understand that a decision needs to be made? Let's look at some of these questions. Do they have the ability to understand essential information and use it to make decisions? Do they have that ability to compare risk and benefits? Or do they understand the potential consequences of decisions or options? And again, that important piece, do they have that ability to communicate those decisions to appropriate parties? So let's discuss incompetency. Before a guardian can be appointed, you must first have the individual determined incompetent by the court. And for our purposes here, talking about guardianship, this is strictly a legal term used in a legal proceeding to determine if guardianship for an individual is appropriate. That term, incompetency, is a very harsh term. It is the term that North Carolina uses. Some states use the word incapacity. But the definition is a simple definition. It says a person who lacks sufficient capacity to manage his or her affairs or to make or communicate important decisions concerning his or her person, family, or property. So it is a legal term rather than a medical or social determination of the adult's capacity to make those important decisions and manage their affairs. The problem is that there is no real test for this, and it's very challenging to assess. Capacity can change over time. Think about how much you as maybe a parent or a trusted loved one, how much you've changed and your abilities have improved over time depending on your experiences in your life situations. So looking at that capacity part, capacity refers to the person's present level of decision-making ability or likely ability when faced with a future situation requiring a decision. So thinking about safety, look at and consider the level of risk for being exploited by others. Does the individual not understand or comprehend warning signs or signals for dangerous situations? When you're looking at the financial piece, can they handle money? Can they make change? Do they understand basic banking transactions? Can they pay their own bills in a timely way? Does your individual give away money or other things inappropriately? Could they pick out an apartment or negotiate a lease? Could they be easily exploited by so-called friends, vendors, landlords, or con artists that come their way? In healthcare, do they know what an illness is? Does your individual know when he needs to go to a doctor? Can they express their symptoms accurately and aid the doctor in a diagnosis? Can they understand a risk or benefits of a procedure or medication? Thinking about healthcare, does the individual understand how to take his own medication? What to do if they run out of a medication or they need a refill? What about side effects? When is it important to notify your doctor or someone? Can they make decisions between courses of therapy or treatment? What to do if there's serious pain or suffering? Who's the appropriate person to contact? Who might be needed? What about deciding about routine tests and procedures? It's easy maybe to decide about flu shots, but maybe what about if they are needing to be on a special diet or they're diabetic and they need to follow a regimen of insulin, or they need open heart surgery or something more serious. But just remember that term incompetency, again, is a legal term. It's not a medical or social determination of that person's capacity. If a person lacks that understanding or capacity to make or communicate those important decisions, and by their actions and behaviors, they demonstrate that person is unable to meet their personal needs for health care, for nutrition, for clothing, for shelter, for safety, even with all kinds of assistance and supports, then guardianship may be an option you want to consider. So now what? So we're looking at disability is not incompetence. If an individual has a disability yet maintains the capacity to communicate those important decisions, then guardianship is not necessary. I can't say that enough. Remember that incompetence in one area does not mean incompetence in all areas. It's not an all or nothing concept. The lack of ability to make a decision in one area does not necessarily mean the lack of ability to make all decisions. So it depends on the types and the complexity of decisions to be made. The clerk of court who acts as the judge in a guardianship hearing may find your individual to be incompetent in a limited way, and therefore they can retain certain rights and privileges. And we'll talk about that a little bit later on in the presentation. Excuse me. So you want to begin the legal process after considering alternatives and options. And the clerk of court will consider available evidence at the guardianship hearing to determine incompetency and the need for a guardian. It is up to the petitioner for guardianship. The burden of proof is on them to provide that clear and convincing evidence to the court that the individual's decision-making ability is severely impaired. And there is no other alternative than appointing a guardian. So let's go now and look at defining what is a guardian. So a guardian is an agent of the court. The guardian is responsible for knowing the values and wishes and beliefs of the represented adult, with given authority to make decisions for the adult that are reflective of these. The court is going to generally consider 3 questions when deciding whether or not to appoint a guardian. First, they look at, is the individual incompetent? They're going to look at, are there any less restrictive alternatives? And then they're going to look at, is the individual applying to be a guardian suitable? So who can be the guardian? It's really pretty straightforward. A guardian who is assuming the role of a substitute decision maker. The requirements are few. They have to be age 18 or over. They need to be a resident of the U.S., not convicted of a felony, but there are some exceptions for that. And they need to be of sound mind and not in need of a guardian themselves. You don't have to have any special training to petition the court to be a guardian for someone. But the selection of guardian is at the court's discretion. Anyone can petition the court that an individual needs to have a guardian, but the petitioner is under no obligation to be the guardian for that person, even if they're the family member. So the court's going to consider, is there a relationship to the protected person, and how well suited is that person that's petitioning for guardianship? Are they well suited to managing the financial or medical needs of the individual? So an individual or agency appointed by the court to help an individual exercise his or her rights, this is what a guardian is. So they can, depending on the type of guardianship, they can manage finances, property, health care, or deal with the personal affairs and day-to-day care. So just a couple of quick facts about what a guardian is. The guardian is not required to financially be responsible for the ward. The guardians are not expected to use their own funds to support the ward. The guardian is not obligated to have the ward live with them in the same household. They are not liable for the ward's past debts. The guardian is not legally or criminal liable for actions of the wards. However, if the guardian fails to fulfill their duty in some way or is negligent, and this leads to the ward's destructive or damaging behaviors or activities, then the guardian could be held responsible for some of that. So we want to look at the types of guardianship. For adults, there are three main types of guardianship. There's guardian of the person, guardian of the estate, and general guardian. So guardian of the person, this is an individual agency appointed the authority to make decisions ensuring the care, custody, and control of the ward. So what we're looking at is they're taking care of those day-to-day decisions. They look at medical care. Maybe they need to give consent for needed services or therapy. They make sure the ward receives proper personal care, that they're clothed and fed. They arrange for education. They are going to be dealing with where this individual lives, where is their ward going to be placed. If they will work and connecting them with any kind of vocational assistance. They're also responsible for taking care of any of the ward's personal belongings. And sometimes they may end up needing to go to court and taking legal action to protect the ward if necessary. They do not have the authority to make any decisions concerning those large financial matters. That will be up to the guardian of the estate. Now, the guardian of the person can handle small amounts of money if they have a small job and small funds, or they can apply for benefits like Medicaid or Social Security, and they can deal with those amounts of those financial matters. But no bond or accounting is required if they are a North Carolina resident. And the question comes up a lot of times when we're working with families and individuals. Under certain conditions, you can have an out-of-state resident that can be appointed the guardian of the person, but you really, because of the day-to-day decisions, you really want to think about having someone close by that can keep tabs on the ward. Now, the guardian of the estate, again, it can be an individual or an agency appointed the authority for managing the ward's financial matters, their benefits, real estate, and other property. And for this, a bond is required. And a bond is like an insurance policy. It's required by the court in an amount set by the judge to cover the assets of the state. They do not have the authority to make any decisions concerning that personal care, which the guardian of the person will be responsible for. So it is required for the guardian of the estate, before any of the property or benefits, any of the money is turned over, that the guardian of the estate has to do an inventory that's filed with the court after they are appointed. They look at the property values, real estate, other assets. And they also must file annual financial accountings of the ward's assets with the court and how their money and assets have been spent. The guardian of the estate must be a North Carolina resident, but under certain conditions, they can be an out-of-state resident if they agree to comply with North Carolina law and have an agent here in the state to receive any paperwork or any documents that's served. General guardian, this is a individual or agency acting in combination. So this is they're taking care of those personal care, those day-to-day decisions, but they're also dealing with all the financial matters. That's the general guardian. So guardianship can also take several forms, and I want to just mention joint guardianship. This is where sometimes families think this will be a great idea because if one guardian is sick or out of town or out of the state, then the other guardian can respond and take care of matters. That's not what joint guardianship means. Joint means both must agree and act together. So if you have someone that's traveling or that you can't get in touch with them, the one sole guardian cannot make any decisions or sign or consent to treatment or make decisions alone. There's also something called legal guardianship. This is where the guardian's powers are limited to those granted by the court. It allows the ward to preserve as many rights as possible. It's appropriate for individuals who may be impaired in taking care of themselves or maybe their financial assets, but not to the extent that a full guardianship is required. You know, the individual may lack the capacity to perform some but not all tasks. So this limited guardianship option encourages the ward's maximum self-reliance and independence by the court limiting the guardian's power and authority over only those areas that are necessary that the individual is unable to handle. Now, there's also something called an interim guardian. This is an emergency guardian. It's not necessarily emergency for you, but it means this is when you have a case where an individual is in immediate harm, imminent danger, and they will go ahead and assign a guardian for a certain number of days without all the process and the full hearing. But this is something that you don't want to wait and make a decision till there is an emergency, because at that point you need to be focusing on that individual and making those decisions on the ground as in a timely way. You don't want to have to be at that point going and petitioning the court to get this assigned if possible. Okay, so now we're going to talk about if guardianship is assigned, what kind of rights may be lost to an individual. So, you know, an individual does lose a great deal of independence under guardianship. Guardianship restricts the person's general rights and freedoms. The first thing, their self-determination. They lose their freedom to make choices about services and supports. They lose their authority to determine how their income or monies are spent and used. They are no longer accountable or can contribute to the community. They lose the right to associate freely. They are not allowed to serve on a jury. They're not allowed to independently file a lawsuit. They can go to court and file a lawsuit as long as they have an attorney, a guardian, or a guardian ad litem to do that for them. The Department of Motor Vehicles may deny them the privilege to drive. The burden of proof is on the ward to rebut that revocation of license. So they can request a hearing in writing and to be able to try to retain their driver's license. But there are some rights that do remain, and the ward can register and vote. And thinking about contracts, marriage is a contract. So if there's sufficient capacity to understand the nature and consequences of marriage, yes, maybe they can marry. Other contracts, you know, guardianship doesn't necessarily take that away. It may make contracts voidable, but not necessarily void. So you may have a ward that goes out and signs up for a cell phone, and that's okay. They understand about taking care of the cell phone and paying the bill. But if someone, say some so-called friends, talk the individual into leasing an apartment for them and paying for all that, then the guardian could come in and void that contract. Again, the right to make a will. They have to be they're presumed incompetent, but they can rebut that presumption. And again, the Department of Motor Vehicles on the issue of driving, if the individual's had a driver's license before 18, they have to show that they're competent to drive. Excuse me. The right to be a witness, maybe that right will remain. It depends on if they're able to understand that obligation of what an oath is, about telling the truth and consequences. Do they have that capacity to observe and remember and relate things that have happened in an event? So the right to be a witness is based on an independent examination by the judge in the case. So the judge is mainly going to ask, does the ward understand about telling the truth? Does the ward understand what they're in the courtroom for? So some of the duties of a guardian, it's very important for the guardian to understand their duties and responsibilities. Guardianship is not set up to be a dictatorship, but think of it rather like a limited partnership at times. Guardianship is not about controlling an individual who maybe makes choices in his life that the family disapproves of. So depending on the type of guardianship established, the guardian has certain statutory required duties. And a good guardian should offer the ward the opportunity to participate as much as possible in making those decisions affecting them, as much as they can handle, as long as those decisions don't harm the ward. Decision making is such a learned skill. It requires practice. If possible, the guardian should teach the ward about making sound decisions, allow practice of this skill when possible, and if the individual is determined by the court to retain some capacity for rational decision making, especially, hopefully this will be used. A guardian is obligated to make decisions and must always act in the best interest of the ward. And they should be taking into consideration the ward's own wishes. Now, a guardian cannot prevent the ward from making all unwise or bad decisions, bad choices, but the guardian does have veto power. They can override those poor decisions that would harm the ward. So before getting started, thinking about is guardianship needed, one of the great benefits of guardianship, it does provide two important layers of protections, the guardian and then the oversight of the court. Guardianship is established in the county where the respondent lives, where they reside, not where the petitioner is from. So you want to first consider any alternatives or less restrictive options. You know, think about what alternatives have been considered and tried. Do you have the capacity and the time to carry out the guardian's duties and responsibilities? Is an attorney necessary? Possibly. If you have a very complicated family situation, maybe there's a lot of property or a large estate, you may want to talk to an attorney and sort all that out. When can the process start? As we said, you can start no sooner than they're 17 and a half years old, but you can also apply for guardianship past that age of 18. What forms are required? There are a number of forms, and I've got it on a slide coming up in the next little bit that will specify those forms that you're going to need to petition for guardianship. And how do you get a court date scheduled? The court date is assigned after the forms are completed and the petition is filed. And then what happens next? So it's important to educate yourself. Again, I'm repeating myself, but this is so important that you understand the duties and responsibilities of the guardian. So depending on the type of guardianship, there may be status reports, there may be an inventory, there may be annual accounting that you're responsible for and turning into the court and reporting back to the court in a timely way. So just real quickly, let's review some of the players involved. I know when I went through guardianship with my son, some of these terms, I had to set them down on paper to not be confused with who did what and what was what they meant. So the clerk of court acts as a judge in the guardianship hearing. The guardian is the individual or agency that's awarded the authority to act on the ward's behalf. Guardian ad litem, this is, we call them, you'll hear me refer to them as a GAL. They're appointed to represent the respondent's best interest to court. Their main purpose is to gather information or investigate. They do the fact finding to protect the best interest of the respondent and make recommendations back to that clerk of court. For an incompetency proceeding, the guardian ad litem will always be an attorney. The fee is paid by the state of North Carolina. If an individual has their own private attorney, then the guardian ad litem could be discharged from the case. But the guardian ad litem is charged with meeting the respondent personally. They may meet with the parents, they may meet with neighbors or trusted folks or providers, just to whatever information they need to gather on the respondent and the situation. The guardian ad litem will contact you, or you can contact them. You can share information with them. They may ask you to sign some releases to allow them to talk to your healthcare providers. Their contact information is going to be on your notice of hearing form that we'll talk about coming up. So you'll have their contact information. But the guardian ad litem makes recommendations to the court of the respondent's best interest, even if that is contrary to the respondent's expressed wishes. And those recommendations are given at the hearing. The petitioner, this is the individual or agency filing a petition for guardianship. The respondent is that individual who is being assessed for incompetency and the need for guardian. Now, the sheriff comes into play because the sheriff in North Carolina by law must physically serve the petition paperwork to the respondent. And the ward is the respondent after they are determined to need a guardian. So this is the individual that has an appointed guardian form. So the forms that we would need to start guardianship, where do you find them? You can go online and type in online the form number and pull them up. All the forms are available at the Special Proceedings Division on the state's website. Or you can request a packet of guardianship forms, and most of those are available in most of the counties now across the state. The clerk of court staff, just to remind you, they cannot provide legal advice, but they can provide the forms and information about what documents you need and about the process. So as a petitioner, again, the burden of proof is on you to show that individual is incompetent, that you need to make specific allegations on a petition. If you need witnesses, all of this, the burden is on you as the petitioner. So every county is different, and you want to check with the clerk of court office in your county and ask questions if there's any specific requirements concerning whether they require document notarized or they need a letter from a medical provider, those kind of things. But let me go back here to the forms that you're going to need. There's the form AOC SP 200. This is the actual petition for guardianship. The other form, AOC SP 201, notice of hearing on incompetence. That is required. the form AOC SP 207, Certificate of Service. Again, that will be given to you and is required. But there's an optional form here, the AOC SP 208, the Guardianship Capacity Questionnaire. This questionnaire was designed to help you think about whether or not a guardianship is necessary or provide, or whether alternatives might be the right avenue for your individual. The questions are divided up in like 10 life domains, and it helps you sort things out. It's not required, but it may be something you want to take a look at, either while you're trying to just determine if this is the process for the option that you want to take for your individual, or it may be something you want to include and give to the court to help them understand and have a better understanding of the function level of your individual. So a medical letter is not absolutely mandatory, but it's a good idea. And again, I would ask the clerk of court staff about what their particular wishes are in this matter, but you can submit a written letter from a medical provider. It has to have more than a diagnosis. You must include the individual's level of functioning, decision-making ability to support that claim that guardianship is necessary. Some of the clerk of courts don't mind it as long as it's on the letterhead from the doctor. Some clerk of courts in some counties want it notarized. So again, just ask the staff what their particular wishes are in that. But a simple statement of just a diagnosis is insufficient. You may want to start with a medical provider that's very familiar with your child, or a psychologist or a therapist, something like that. You can also include for the court evaluations by other care providers, school staff, any performance records, any prior medical records, anything that you think is of value to prove and provide evidence about the function level of your individual. That would be something helpful. If the clerk of court is looking over the recommendations from the guardian ad litem and it does not have a clear picture, they can request that the individual go for a medical examination to bring that information to the hearing and have that as part of the record. So it's nice to include a medical letter and have that done from the first. Okay. So now let's look at beginning the guardianship process. You have to file, that's how you initiate the guardianship proceeding. You're going to start by filing the petition with the Special Proceedings Division in Superior Court. And you're going to take that form, AOC SP 200, that petition for adjudication of incompetence, and it goes on with the long title there. I'm not going to take time to read it all, but that's the form that you need to fill out and return to the courthouse. You're going to complete and submit those forms, and then you want to also bring your calendar with you when you come to the courthouse, because the incompetency hearing is typically scheduled 3 or 4 weeks from your filing the petition. So they're going to actually put that date of the hearing on a copy of a petition for you. If you're going to be away from home on business or vacation, make sure you make the court aware of that. You have to allow time for the sheriff to serve the individual with the petition. You have to notify next of kin. You have to allow family and interested parties to make arrangements to attend the hearing. You've got to have time for the guardian ad litem to meet with you and your child. So you don't want to file the petition and then be away from easy contact for all that to happen. All right, and so the form AOC SP 207, the certificate of service, that's going to be given to you. you can complete it and return it later when you come back at your hearing date. So the next step in the process is that you're going to comply with the statutory requirements, and that is notifying next of kin, interested parties. You have to file this within 5 days of filing your petition with the court. So you're going to make a copy of the form AOC SP 201, the notice of hearing, and you're going to have a copy of the form AOC SP 200, the petition for adjudication. And you're going to be sending that out. It specifies on the form who gets that. It may be if they have a spouse or relatives, if they're adult brothers or sisters in the home, if there's adult children, if there's grandparents, those kind of immediate next of kin would go on that form. So the form that they give you, the certificate of service, that AOC SP 207, you can bring that to the hearing. You've got two options. Now this, again, you're conforming with statutory requirements. This form, it documents and confirms your timely delivery of the necessary forms, that you've notified next of kin, you've notified the interested parties of the respondent. So you can either complete the form, have it notarized and bring it to the hearing, or you can complete the form but don't sign it, and then bring it with you to the hearing and sign it in front of the appropriate court staff at that hearing date. So once the clerk of court issues a notice of hearing, they'll appoint that guardian ad litem to represent the respondent, and the guardian ad litem can be discharged if the respondent has their own personal attorney. But the guardian ad litem is the eyes and ears of the court. So they're going to inform the respondent of their rights, explain about guardianship. They're going to ask the respondent's opinion about all kinds of different things regarding guardianship. So the guardian ad litem must personally meet with the respondent or make a reasonable effort to determine the respondent's wishes. And then they're going to bring that information back to the court. They're going to make their recommendations, and they're going to add their opinion as to the respondent's competency, whether or not they need a guardian, who would be the best person or agency to serve in that capacity. They also will recommend what type of guardian is needed and what type of, whether limited guardianship is an option. Now, under North Carolina law, it requires the sheriff to personally serve a copy of the petition to the respondent. For some individuals that maybe have not had a really positive encounter with law enforcement, this can be a little bit traumatic for some of our folks. But sheriff or their deputies, they are pretty sensitive to this, and so they're very willing to work with you. You can sometimes call and ask to take a tour of their office, and that petition they can arrange to serve the paperwork there as the individual's taking a tour of the sheriff's office. Sometimes you can arrange for them to come and they will not be in uniform. Sometimes they will come and if you have someone to agree, they can call ahead and you can have a little bit of head notice instead of just someone knocking on your door and you're opening it and it's the sheriff's deputy for them. Again, depending on your individual, what you need, you might consider social stories or role playing, just trying to prepare your child for this part of the process. And then, the respondent's involvement is a personal choice. They are not required to be at the hearing. It's not mandatory. So you want to, again, evaluate how your individual can handle the process. How do they do meeting with the guardian ad litem, being served by the sheriff, attending the hearing, again, personal choice. But think about if there's witnesses, if it's there's a lot of conflict going on, or they're going to be talking and discussing the levels of limitations for this individual, and it would upset them. You may want to think whether or not they need to be there or not. So at the hearing, it's important you arrive early. Uncontested hearings can take place in a conference room rather than a courtroom. For my son, I was petitioning for guardianship. I was the only one doing that. We didn't have a large estate, so there was no family conflict. There wasn't a lot of other issues for us, and so it was a very straightforward, simple process. But if it's not, the respondent can ask for a jury. If they oppose this, or if they want to have witnesses brought, they can certainly do that. They can ask for a jury. The clerk of court will, at the hearing, determine and hear the guardian ad litem's report. They'll hear testimony and arguments. If you have witnesses, they'll be allowed to testify and you can cross-examine them. They're going to consider any affidavits from the medical provider, but they're going to determine based on the evidence presented whether or not that respondent is incompetent. So this is where the burden of proof is. You want to make sure that you bring everything to bear at that date of hearing, that you have it all, that you've talked to the guardian ad litem, you've brought the evidence that you need to convince them that yes, this person does need that safeguard of guardianship. They do need that extra layer of support and safety. At that hearing, the clerk of court is going to either appoint the guardian, or they're going to dismiss the petition for lack of evidence, or if you have not followed the procedure and filed the paperwork in the correct timeline, they can dismiss the petition for that. So the final process is a guardian cannot be appointed until the respondent has been judged by the court to be incompetent. And once incompetence is declared, that judge will decide who will be the best person to serve as guardian and then appoint them. And so the hearing will determine the powers, the duties, even the limitations of the guardianship. And the clerk of court who's acting as judge will determine the rights and privileges retained by the ward. So afterwards, after the guardian is appointed, the guardian will go to the estates division and complete all other paperwork that's needed at that point. They're going to administer an oath to the guardian, and they're sworn in formally. And that oath is just a very simple, they promise to faithfully discharge the duties of guardianship to the best of their ability as required by law. If required, depending on the type of guardianship that's appointed, the guardian will post a bond. And so that bond, if you remember, it's got to be approved by the clerk. It's to secure the performance of the guardian's duty. The bond protects that ward's assets from loss due to a guardian's actions, such as mismanagement or embezzlement. Sometimes it's waived by the court if the estate is very small, but someone at the courthouse or another agency there can handle the bonds if needed. Then you have something called, and the bonds is only required for general guardian or guardian of the estate. It's not required for guardian of the person. The letters of guardianship are issued. These are official documents. They have an official seal. They give the guardian authority to act on behalf of the ward. You want to keep them safe and accessible. You may need to show them to your healthcare providers, to a bank, to the IRS, insurance companies, those kind of things. But the clerk of court will issue these documents at the end of the hearing to the appointed guardian. And, you want to just make sure that you take care of them. They will probably give you about, I think when I went through, they gave me a stack of maybe 10 or 12 letters of guardianship. So like I said, I keep one on my person at all times in case of emergency, but I have them in a fireproof safe so that I can get them if someone needs to have an original copy showing the seal. But it's important for the guardian to understand their powers, their duties, educate yourself on all of that and what the requirements are. You may want to talk to an attorney or trusted advisor to clarify any duties after an appointment if you feel the need for that. So here's a question that comes up for us. Can guardianship be reversed? And yes, it can. The ward, a guardian, or any interested person can file a petition with the clerk of court at any time for restoration of competency. And this is a process that's very similar to that initial hearing to decide the issue of guardianship. So the court's going to consider any significant changes in the capacity of the ward. They're going to look at any significant changes in the need for guardianship services. You may have an individual who maybe over the years through they've learned, they've practiced some decision-making skills, they're able to take care of some decisions that maybe they couldn't do when they were younger. And so you want to give them additional rights. Sometimes through health issues or aging, maybe you've got someone that is losing their ability to take care of some of the things that they were managing before, and so you need to restrict some of the rights. Or you may change the type of guardianship. Maybe they've come into an inheritance, or maybe there's a property or estates now that this person has. But the modification does not include changing who the actual guardian is. Now, it is possible to modify guardianship, but it's very difficult, so it's not something you want to just take lightly. But again, the ward has the right to petition the court at any time for this. Now, the end of guardianship. Guardianship lasts until it's revoked by the court. So a guardian may be getting older and not able to execute their responsibility, or maybe they've moved out of the state or country. A guardian can be changed if they resign or if they're removed for cause or die. So, we're looking at the ward's competence is restored. So again, they would go through the process, they go through the court and have the clerk of court decide that, and then guardianship would be ended. If the resignation of the guardian, say for some reason they cannot fulfill their duties any longer and they want to resign, they can't just stop doing guardian duties. It has to be accepted by the court, and the guardian has to give a final accounting if they're, say, the guardian of the estate or general guardian. The court has to give that approval after that final accounting is turned in. Maybe there's the death of the ward. Again, that would end guardianship. This is something that, again, learning about the duties and responsibilities, you want to also make plans for doing burial services and putting those things in place before the actual death of your ward, so that you still have the authority to take care of the money and paying for things, or you may have to go and petition the court for an extension to take care of those final details for the individual. The removal of a guardian by the clerk of court, that can certainly happen if the guardian has been neglectful or they fail to do their duty or comply. There are situations where mandatory removal is called for, such as if the guardian is incompetent, if the guardian has a felony conviction, or if they are initially unqualified. Maybe there was fraud in obtaining the appointment, or they failed to renew a bond, or they failed to turn in their accountings. That would cause them for the that would cause the clerk of court to remove them. So again, the ward can file a petition with the clerk of court at any time to decide about the status of guardianship. That does remain their right. So we've considered all the things about guardianship, but let's look at maybe guardianship option is not exactly what your situation needs, and you're thinking, okay, well, what else can I do? What other supports are there? There's a number of alternatives to guardianship, and there's a link on our slide here at the end on our online resources to Disability Rights of North Carolina. They have a great article on alternatives to guardianship. But in many situations, guardianship may be, although it may be the most appropriate and necessary fit for the situation, it's important to remember these less restrictive alternatives that are available. One nice thing about the alternatives is they do not require determination of incompetency. They're much less intrusive. They're person-directed. They're voluntary action put in place. They can be quickly implemented. Some of the pros and cons of that, though, is they can be easily modified or revoked by the individual. So let's take a look at joint bank accounts. So that can be created maybe if you have someone that tends to spend money or doesn't understand budgeting or saving. Arrangements can be made with banks for that. You may have you can have 2 or more signatures on there for all withdrawals. The only problem is that the money is considered all of the respondents, and the money is also considered all of the person whose signature is on that joint bank account. So again, if someone leaves with the money or withdraws that, there's no protection under that for the individual. Automatic deposits, you can set this up for benefits like benefits check, or maybe they're working a job and they want their paycheck sent into their bank account automatically. It can be a permanent withdrawal rider can be helpful. This is where maybe you have someone that can take care of their money and they can pay bills, but maybe they're not the best on making sure they get their rent paid on time or their utility payment on time. So they can make arrangements with the bank that authorizes the bank to send out certain sums of money on a regular basis to a specified party. Representative payee with Social Security. You don't have to be a guardian to be the representative payee. You could do this as a separate thing. But this is an individual who is receiving benefits, but maybe that they're incapable of managing their money. The representative payee has to be approved and appointed by Social Security, and this means that that individual receives the benefit check and they spend it on the care and needs of the person. They have to give an accounting to Social Security and make sure that that money is only used for that individual. So there's also health care and financial powers of attorney, which may be a great alternative for some. You have to be competent to sign. You have to be 18 and over to sign a power of attorney. But this is where the individual assigns authority to another to be their agent, to act for them under specified terms and conditions. They can change it at any time. And they can determine when that goes into effect. So it could start that day they sign, or maybe it only starts when they're incapacitated or having more problems like in a car accident. There's something called durable power of attorney, and this is, again, you have to have the capacity to sign it. It's voluntary, but it remains in effect after the person is incapacitated. So with special wording, so if the person does lose competency, that power of attorney, that durable power of attorney stays in place. So you have to file and register it at your county's Register of Deeds. Now there's also something called Special Needs Trust, and this is a financial arrangement to appoint a trustee and manage money and any disbursements. You can fund what's important to you, what's important to that individual. So if worded correctly, it can protect future government benefits. It should be set up with the help of an attorney or a lawyer who's very experienced in wills, in trust, and very experienced with the laws relating to government disability benefits. A trust set up without regard and expertise in those laws can disqualify a person down the road from Social Security or Medicaid or those other important benefits. Some more alternatives to guardianship. There's an advanced healthcare directive. This allows the person to state their instructions or preferences regarding future medical treatment. If they become incompetent, there's a living will. You can tell your healthcare provider what it is you want to happen. You have to be 18 years old to start one. You have to be competent to sign it. But it provides advanced instructions about what it is you want, how you want the future care to be. It gives the doctor permission to withhold or withdraw life support under certain conditions. So you want to take a look at that and make sure you understand what it is you're signing. And it can be revoked by communicating that desire to your doctor. You want to look for, when we're talking about these alternatives, you want to look at the right support for the right task. And looking at in-home supportive services or any family and friends, faith-based, community supports, social workers, visiting nurses, you just want to get the right support for the individual. Home health services, home health care. Maybe you have someone that's not so good on doing those activities of daily living, or they're not able to cook a meal, a healthy meal, or maybe they're not as good at cleaning. You can hire home health services to come in and assist the person. There's also other kinds of trusts, not just special needs trusts, but they have all kinds of different services and departments. The bank trust department that can handle money and pay bills. Again, they all have their different specific things, so do your research on that and see what works for you. So just to review kind of what we covered today, like I said, make sure you research those least restrictive alternatives before absolutely deciding on guardianship as an option. Incompetency, please remember that it is a legal term rather than a medical description. Only a judge can determine incompetency or incapacity, not you, not your doctor, only the judge in the guardianship hearing. The guardian's authority may be full and complete, or it can be limited. The three main types of guardianship for adults are guardianship of the person, guardianship of the estate, and general guardianship. It's important to understand and perform the duties and responsibilities of the guardian. And there is a process for modifying guardianship. It does not change, however, who's been appointed guardian, but termination of guardianship may occur under specific situations. So we have some additional online resources, disability rights. I encourage you to go on that site and look at a lot of great information on guardianship and the alternatives. Um, Guardianship of incapacitated adults, that's a great one. There's information, the frequently asked questions about guardianship from the NC courts. Again, this document, Responsibilities of Guardians in North Carolina, it gives you that information that you need. You may want to take time and look over that. And the others you can take a look at, and that hopefully will be helpful to you. And then we also have the Autism Society has a number of online resources. Take time to look at the Guardianship Resource Guide if you'll click on that link. We also have autism resource specialists across the state. They are a great resource for you to use and have a lot of information for you. We have a number of toolkits on our website that are hopefully be helpful to you. And our blog, let me encourage you to go on this. There's just a number of different articles about all different subjects. Great wealth of information. I really encourage you to take a look at that and hope you find that helpful. So thank you very much for viewing our webinar. You can reach us by calling or emailing us at the above information. My contact information is, again, I'm Jan Combs, and my email is jcombs@autismsociety-nc.org. If you have any questions about today's webinar, please get in contact with me. Take care.